Real estate license exams for dummies. Part 2. So you want to sell real estate, a job, and the basic laws. Chapter 4. Understanding agency law. In this chapter, choosing and establishing an agency relationship, looking into the duties of an agent to a principal and the customer, find out ways to pay an agent and when, discovering how to end the agency relationship. Chapter 4. Understanding agency law. My guess is that the kind of agents you're most familiar with is the Hollywood agent, and that's a place of any to start talking about the word agent means. Before and after the big parties and movie premieres, what does an agent do? An agent represents a client, and that means that the agent also always works for the client's best interest in any deal that the agent negotiates on behalf of the client. The agent tries to get the client the best role in the movie for the most money, or may try to get the client a bigger dressing room at a studio. Real estate agents are no different. They represent their clients and always work in their best interests, except that the work isn't about better movie roles and bigger dressing rooms. It's probably about better price for the house or faster sales, regardless of whether they're located in Hollywood or Topeka. And whether they're negotiating salaries or house sales, the relationship between agents and the people they represent comes in duties, responsibilities, and expectations. In this chapter, I discuss all the important agency relationships and its main players. I talk about how to establish such a relationship and define the elements of relationship between the agents, principals, who are also called clients, and the customers. I tell you about payday and who pays the agent and when. And I'll let you know how to end an agency relationship. Every chapter in this book is important and fair game for the questions on the real estate exam that you're going to take. They said be sure to pay particular attention to the information in this chapter. People who buy and sell houses and other real estate continues to misunderstand the agency relationship. Although the situation has been getting better, various states are aggressively in making sure that their real estate agents understand the agency relationships, can act accordingly and appropriately, and can explain its nuance to the people who use their services. Specific type of agency relationships in law govern agencies vary a great deal from one state to the next, but the information I give you in this chapter is pretty much generic and therefore applicable in all, if not all, states. As such, you need to pay particular close attention to the way your state deals with the entire subject of agency, so that you know exactly what the agency rules are and how agency relationships are conducted. Through the years, the states have increased the number of hours they require in coursework on agency laws, which in turn means that more emphasis is placed on the subject in the state's licensing exam. So be prepared for a bunch of questions about agency laws on your exam. Becoming someone's real estate agent. You're hired. In this section, you find information about some important parts of agency law, who are the represented, and how the agency relationship is established between you and the client. Picking sides, representation in agency relationships. You think that defining or establishing just who you represent is just an easy question to answer? In fact, you're probably amazed that I'm telling you right now that many real estate agents, buyers, and sellers either are confused about what constitutes an agency relationship from the beginning or seem to forget about it along the way. I explain why this confusion exists at some time that I give you information about that clarifies who you represent in the real estate agent transaction. Getting to know you, agents, principals, and customers. Several people are involved in any given agency relationship, but first I need to make sure that you understand who you are within the arrangement. An agent is someone who is authorized to represent the interests of another person. The three different types of agents in the order of least to most authority includes special agents. The agent who is hired by someone to represent that person in one transaction. A real estate agent who represents someone in the sale or purchase of a home is considered a special agent. In some states, this type of agent also is called a specific agent. General agent. An agent who represents someone in a range or a group of activities. A property manager who collects rents, pays bills, authorizes repairs, and negotiates leases, among other tasks, usually is considered a general agent. See Chapter 3 for more on the property management. In some states, the universal agent. See the next bullet point is called a general agent, so make sure that you know the correct terminology for your state. Universal agent. An agent who acts on the client's behalf in all matters and situations. Someone who has the power of attorney to act on someone's behalf in all real estate matters is an example of a universal agent. I talk about the relationship between brokers and salesperson in Chapter 3, but I want to say something more specific about brokers, salespeople, and their agency relationship. Licensed real estate salespersons work for and under the authority of the licensed broker. The agent in the agency relationship is the broker. The salesperson is considered an agent of the broker and is a sub-agent of the seller or buyer, depending on who the broker is representing, forming one of the many common types of sub-agencies. However, enlisting the help of other brokers in the sale of a property is equally as common an idea. This can be done through a local multiple listing service, looking at listing agreements later in this chapter, or with individual brokers. These other brokers, who often are called cooperating brokers, also may become sub-agents of the seller. It's not common to enlist the aid of the other brokers when a broker is representing a buyer. The point is, you need to check out the specific responsibilities of sub-agents and characteristics of the sub-agents in your home state. But I never said that vicariously liability. There's a problem with the sub-agent relationship I described earlier in this chapter. When using a cooperating broker or agent, the client can be held liable for the actions of the sub-agent. Let me give you an example. Say client Jones wants to sell her house and hires broker A to be her broker. That is, her agent gives her broker permission to get help of the other agents to sell her house. Broker A puts word out that the house is for sale, and salesperson C, who works for broker B, comes along and starts showing the house. In this course of showing the house to salesperson C, makes a remark to a particular buyer that they may not be happy in the neighborhood because it's very ethically uniform with many immigrants from one country. The buyer takes offense and considers this a violation of the Fair Housing Act. The buyer would be justified in filing a complaint against salesperson C, broker B, broker A, and seller Jones, because even though the seller has never even met salesperson C, he is working for her as a sub-agent. The courts in these cases have often been reluctant to place blame on the unsuspecting seller or client. States have taken steps to eliminate this situation. At least one state has created something called a broker agent in an attempt to avoid the sub-agent dilemma. In this arrangement, when the client broker enlists the help of other agents, the other agents becomes sub-agents to the broker, but not to the client. In other cases, individual multiple listing services no longer consider cooperating brokers to be sub-agents of the seller, but rather sub-agents of the listing broker. Although sub-agents who vicariously liability to the seller are gradually being eliminated you should check to see if your state has dealt with this issue and how. In addition to an agent, a few other key players in agency relationships are the following. Principal. A principal is the person who represents as an agent. This is the person you have agency relationship with. Client. A client is another name for a principal. Customer. A customer is the other party to the transaction. In a typical real estate transaction, there's you, the agent or sub-agent, the principal or client, such as the seller, and a customer, such as a buyer. The customer is considered to sometimes referred to, particularly in exam questions, as a third party. One or the other. Single agency with sellers or buyers. Most real estate agency relationships are simple agency relationships, meaning you represent either the buyer or the seller. You know who these two people are. But which one is the principal client and which is the customer? The short answer is the principal client is the person with whom you have an agency agreement. That is, the person you agreed to represent. The customer is the third party. That is, the person you do not represent. And this lineup is the same regardless of whether you represent a buyer or a seller. This is important but not necessarily easy information to understand. So let me illustrate. Broker A is hired to sell by seller A to represent her in selling her house. Buyer B hires broker B to represent him as the buyer's agent. Don't worry, I'll cover buyer agency in a little while. In these two relationships, seller A is the principal or client of broker A. Buyer B is the principal or client of broker B. Now let's say buyer B wants to negotiate to buy seller A's property. Seller A now becomes the customer to broker B, while buyer B becomes the customer of broker A. There are other possible relationships, however. There is where it begins. A single agency relationship between agency and clients, with the customer being the third party. Remember that the reason for the confusion is pretty much because the way the real estate business has worked for 10,000 years. Alright, maybe not 10,000 years, but who knows? A real estate agent may have been trying to sell someone a nice, cool, tropical cave with the ocean view, sometimes back in the Stone Age. The fact is that most places, real estate agents traditionally represent the seller, yet spend most of their time with the buyer. And if you either bought or sold a house and used a real estate agent, you probably have a good idea of what I'm talking about. The real estate broker signs an agreement to act as an agent to the sellers to sell someone's house, but the agent may not see the seller again except occasionally to bring people to the house to see it. Meanwhile, the agent spends every Saturday driving Mr. and Mrs. Buyer around looking at houses. Mr. and Mrs. Buyer are the customers. Nothing wrong with this scenario. It is just that the agent who's spending a lot of time with them is so nice and helpful. It might even make a good match for their single cousin actually represents the seller. But the buyer begins thinking the agent represents them, and sometimes the agent begins to act like it does too. In an attempt to clarify things, particularly for buyers, something called buyer agency has been developed. Buyer agency is when the agent represents the buyer instead of the seller. In this case, the buyer is the principal or the client, and the seller is the customer. The rules and regulations covering buyer agency may vary from state to state, so you need to check out how buyer agency works in other states and any specific buyer agency laws that your state enforces. Neat trick. Representing both sides in dual agency. Dual agency is a situation where both sides in a transaction, typically a buyer and a seller, are represented by the same real estate agent. dual agency may actually be illegal in your state, but it's legal in enough states that I have to give some information that should get you through any test questions about the subject. You need to find out from your home state specific laws whether dual agency is legal. If so, under what circumstances? Suppose you agree to represent Mr. and Mrs. Buyer as the buyer's agent to find a house. After working with them for several months with no success, you get a call from Mr. and Mrs. Seller, who wants you to represent them as their agent to sell their house. Just to be clear, you now have agency agreements with both Mr. and Mrs. Seller and Mr. and Mrs. Buyer. At this point, there is no dual agency or problem. However, you now show Mr. and Mrs. Seller's house to Mr. and Mrs. Buyer, and the buyer agrees to make an offer. You are representing both sides of the transaction. That's dual agency. If the state allows it, then there's usual ways to make it legal is to inform the buyer and the seller of the dual agency status and get their consent to continue representing both parties. This is called obtaining informed consent. This is sometimes referred as a limited agency parties. Limited agency because each client doesn't receive a full range of your fiduciary duties. For example, neither party can receive your individual loyalty. I discuss specific fiduciary duties later in this chapter, and keeping the faith, a relationship between an agent and the principal. The man or woman in the middle, transactional brokerage. In some states, the idea that a broker is really a kind of middleman in a transaction between two parties is being given serious consideration. Some states have passed laws creating what is called transactional brokerage, providing for a situation in which a broker representing neither buyer nor seller but can complete a transaction and be paid for it. In such an arrangement, the broker brings the buyer and the seller together, negotiates the deal, and handles some or all of the paperwork. The major difference is that the transactional broker will not represent either side of the transaction. You need to check with your state and real estate laws to find out whether this type of arrangement exists, and if it does, how your state has named the new arrangement. What brokers are called in the situation because they are no longer to be considered agents, and what the basics, duties, and responsibilities are because they are fiduciaries. As you look for these laws in your state, be aware that some states refer to this arrangement as non-agency and to the broker as facilitators or intermediaries, as well as in transactional broker. See keeping the faith and real estate relationships between the agent and the principal later in this chapter for more on fiduciary responsibilities. Letting everyone know agency disclosure requirements. A famous study some years ago indicated that the majority of buyers thought they were being represented by the real estate agent who was driving them around town looking at houses. In almost all cases, the real estate agent was representing the seller, but because the agent was spending so much time and being so helpful to the buyer thought he was their agent and not the seller's. As states began recognizing the confusion that exists regarding who represents who in a real estate transaction, they enacted laws requiring state real estate agents to tell prospective clients and customers who they represent. These laws, where they exist, are referred to as agency disclosure laws. Agency disclosure clears up any confusion for buyers and sellers as to who, if any, is representing them. It also gives them an opportunity to get an agent to work for them if they are not being represented. Disclosure typically is given in writing to both buyer and seller. You need to find out what disclosure requirements, if any, exist in your state. For more about the relationship of disclosure, check out You Better Tell Disclosures later on in this chapter. Establishing the agency relationship and doing it in writing. Representing a party to a real estate transaction as a client and hopefully getting paid for it are based on the agency relationship that you establish with the party. The information in this section about how you can establish agency relationship is pretty universal, so it applies in most, if not all, states. Nevertheless, you need to check what your state licensing law recognizes or prohibits any of the following ways of establishing an agency relationship, and whether your state perhaps recognizes other ways that I haven't covered. An agency relationship can be established either by means of arrangement between the parties, an agent and a principal client, or by means of actions of the two individuals. The first bullet point that follows is the former, and the rest are the latter. You should remember that although I give examples of agent-seller houses to illustrate the following types of agencies, if a statute of frauds in your state requires that all real estate agency agreements be in writing, then it's usually unlikely that you can collect a commission by any of the non-written agencies. For more on the status of fraud, see Chapter 11. Express agency. Express agency is where the agency relationship is created through an agreement in which the agent and the principal states their intentions to enter into agency relationship, that the agent will represent the principal. The parties state or express their intentions in words, either orally or in writing. Whether the oral agreement establishes an agency relationship is binding varies from state to state, so check it out. It may also be possible for an oral agreement to establish an agency relationship, but not to be enforceable by you, the agency, to collect a fee. In typical writing agreement is listing agreement or the buyer agreement, both of which I discuss in the next two sections. The writing agreement is the most appropriate and legal safe way to create an agency relationship. Implied agency. Implied agency establishes an agency relationship through the actions of the two parties. Although nothing formal has been said or written down, the agent and the principal act as if they have an agency relationship. Creating an implied agency may not have been what the two parties intended, but an agency relationship can be created anyways. If you find these circumstances hard to imagine, check out what happened to Miss Seller. Miss Seller is selling her house by herself and puts it up for sale side on her lawn. You drive by, see the sign, and stop in. You identify yourself as a real estate agent and ask some questions about the house. Miss Seller tells you she doesn't want to list the house for sale with any brokerage. She does tell you to feel free to bring any possible buyers around who might want to see the house. The next day you bring Mr. and Mrs. Buyer, who really likes the house and wants to make an offer. You tell Mrs. Seller and begin negotiating the deal. If the matter comes down to commission and lawsuits, only a court can finally decide. But you and Mrs. Seller probably have established an implied agency relationship because of both of your actions. Agency by estoppel. Agency by estoppel is created when the principal doesn't stop an agent from going beyond the agent's normal duties, which thus gives the impression that the agency relationship has been established. Say you're the owner of a building and you tell the agent to show an apartment to a possible tenant. The agent goes ahead and negotiates a lease, even though you didn't give the agent any direct authority to do so. The tenant assumes the agent has authority and the agency by estoppel has been created. Agency by ratification. An agent by ratification is created by accepting circumstances that create the agent after the fact. Suppose a real estate agent, without authorization and without even speaking to the seller, negotiates a deal for a house that the sell by the seller. One day the agent arrives with the completed contract, simply awaiting the seller's signature and acceptance of the deal. The agency by ratification probably has been created. When the seller ratifies what the agent has been doing by accepting the deal, I say probably because the agent wants a fee for his services and may have to sue the seller to collect. When that's the case, the courts determine whether the agent relationship existed from the beginning of the negotiations based on the facts that the seller accepted or ratified the agreement behavior by accepting the deal. Agency coupled with an interest. Agency coupled with an interest is a situation in which an agent has some kind of interest in the property that being sold. For example, suppose a part-time broker is also an architect. The broker architect agrees to design some houses for a builder who's giving the broker architect the listing for the sale of the finished house. In essence, the broker architect made an investment in the project, so the builder can't cancel the agency agreement. If this sounds like a tie-in arrangement and an antitrust violation, see Chapter 3. Remember that the broker architect isn't making one activity conditional on the other. A tie-in arrangement would have been created if the broker had said that if the builder wanted him to sell the finished houses, the builder also had to hire him and pay him to design the houses. In an agency coupled with an interest, it is if the broker architect was investing in the project. Most agency relationships are established in writing and in different agreements for buyers and seller agency relationships. See one or the other. Single agency with sellers and buyers earlier in this chapter. Listing arrangements involve sellers and buyer agency agreements involve buyers. How did you guess? Within the two categories are differences kind of agreements. Many details within various types of arrangements are similar with respect to the duties to be performed. The difference usually deals with the circumstances under which an agent will or will not get paid. The issue of payment of the broker fee, which is covered in most details in Making Money. No, not at the copy machine later in this chapter, usually related to who is procuring the cause, the buyer or seller. The procuring cause means the person who found the buyer or seller and made the transaction happen. Often it refers to as the person who brought about a meeting of the minds between a buyer and a seller. It also may be defined as a broker who brought a ready and willing and able buyer to the deal in terms of acceptable to the seller. Looking at listing agreements. A listing agreement establishes an agency relationship between the agent and the property seller. The agent agrees to represent the seller in marketing the property. Here are the names and descriptions of the 4 types of listing arrangements in order that they are more commonly used. Exclusive right to sell listing. In this type of listing arrangement, a broker is given the exclusive right to market a property on behalf of the seller. The broker is paid regardless of who sells the property, an especially important point because it distinguishes this type of listing arrangement from the others. It clarifies the owner always retains the right to sell his or her own real estate. Even so, while the listing agent is in effect, if the owner sells the property without any help from the broker, the owner still has to pay the agreed upon fee to the broker. Exclusive agency listing. In this type of listing arrangement, a broker is hired to act as an exclusive agent representing the owner in the marketing of the property. The broker, of course, earns a fee if the property sells. However, if the owner of the property sells the property without any help from the broker, the property owner won't have to pay the broker fee. Open listing. Notice anything missing from the name of this type of listing? The word exclusive is taken out because the property owner has the right to use as many brokers as needed to sell the property. No broker has exclusive rights to represent the owner. This type of listing sometimes is called non-exclusive or general listing. The owner who sells an open listing property without any help from the broker is under no obligation to pay a fee to any broker. If a broker doesn't bring a successful buyer to the property, the owner must pay the broker a pre-agreed fee. Net listing. A net listing is a listing for which a broker is hired to sell the property for a certain amount of money, called the net amount, the net price. The broker keeps any amount in excess of the net price. So if you take a net listing on a house for which an owner wants to net $200,000 from the sale, and you sell it for $225,000, and you get to keep the $25,000 as your fee. Note, net listings are illegal in some states and disclosures in others. Some states allow it only if the maximum commission to be earned by the agent is made clear to the seller in writing in an original listing agreement. Check out your state law about this kind of listing. Questions about net listings tend to be favorites among test writers, especially if it's illegal in your state. In addition to these 4 types of listings, you may encounter something called an option listing. An option listing is not as much as a listing as it is a clause in any listing agreement that gives the broker the right to buy the property. Check out the local state laws to find out whether option listings are allowed and what conditions or requirements may be imposed when using an option listing. You can see the danger and conflict of interest here, so states that do permit them tend to regulate them. More people have probably heard about multiple listings than they heard about listing agreements that we've been talking about. Don't get confused. A multiple listing service or multiple listing system, MLS, isn't really a type of listing as much as it is a marketing service that permits brokers to share listings with other brokers. A broker gets a listing to sell a house and then puts it on the MLS. Tens, if not thousands, of other brokers look at that listing, and one of them may have a buyer for the property. In an MLS arrangement, the broker who has the agreement with the principal is the one who earns the commission of the sale, although he often may split the commission with the other brokers who help bring about the sale. Because multiple listing systems have more to do with marketing than anything else, rarely are there any questions about them on the state exams. I mentioned the multiple listing system briefly here just in case it happens to be used in an incorrect choice or a question, or probably as a correct choice for a question that has to do with which choice is not a type of listing arrangement. Examining buyer agency arrangements. Traditional real estate brokerage continues to be the primary representative of sellers. However, a buyer becomes aware that they did not have representation in a real estate transaction. Buyer agency agreements were developed to enable the buyer to become the principal and thus have all the advantages of being represented by a real estate agent. The several types of buyer agency agreements differ primarily in the circumstances under which a broker is paid. Here are typical arrangements. Exclusive buyer agency arrangement. This agreement makes the broker the exclusive agent for the buyer, and no one who finds the property that the buyer is seeking a fee is owed to the broker. If and when the buyer buys the property, even if the buyer buys property directly from an owner with no broker involved, the buyer still has to pay an exclusive agent a fee. This type of arrangement is called an exclusive rights to represent. Exclusive agency buyer agency arrangement. This arrangement makes the broker the exclusive agent of the buyer, but it requires the broker to be paid only if the broker finds the property that the buyer ultimately purchases. If the buyer finds property or buys it without the help from the broker, the buyer owes no fees to the broker. Open buyer agency agreement. This agreement enables the buyer to enter into an arrangement or agreement with any number of brokers and is therefore not an exclusive type of buyer agency agreement. The buyer pays only the broker who finds the property that the buyer buys. The buyer owes the broker nothing. If the buyer finds and purchases property without the help of a broker, the buyer or seller may pay the fee in a buyer agency agreement. Fiduciary responsibilities. See the next section. Doesn't follow the money. A buyer agent who owes complete fiduciary responsibility to the buyer can be paid from a portion of the commission paid by the seller to the seller's agent. This is no different from when a fee is split in a co-brokering arrangement in which both brokers represent the seller except for one who is represented. See Making Money. No, not at the copy machine. Later in this chapter for more. Keeping the faith. A relationship between an agent and the principal. The elements of an agency responsibility to the principals are summed up in one word: fiduciary. Fiduciary means faithful servant, an agent and a fiduciary of a principal. In a real estate transaction, the principal is also known as a client. It can be either the seller or the buyer. See Getting to Know You, Agents, Principals, and Customers early in this chapter. The agents faithfully represented the interests of the principal above all other interests, including the agent's own. The specific fiduciary responsibilities of an agent have been handed down by the practice in common law. What people have done and how the courts have interpreted those actions. Some states examine the fiduciary duties of real estate agents and incorporated them with their respective real estate license law. Don't forget that an agent owes a fiduciary obligation to the principal or client. I discuss other duties and obligations that are due to the customer in meeting obligations, the relationship between the agent and the customer later in this chapter. Although I discuss a fiduciary responsibility so that you have a good general understanding of the subject for exam purposes, you nevertheless need to check out your local state interpretation of the fiduciary duties so you are more in line with the specific questions you may encounter on each state's exam. Because fiduciary responsibilities are the basis of the agency relationship, exam writers want to make sure that you understand your obligation as an agent. Be prepared to answer several questions on this topic on the state exam. Who has the money? Accounting. As a real estate agent, you handle money and sometimes large sums of it. Most often, you'll handle the money that goes with the buyer's offer to purchase the property. That is variously called the binder or earnest money. These funds are accredited to the buyer and become part of the down payment. Eventually, they belong to the seller, who may be held by the broker for a considerable amount of time. The check may be written to the broker. Other funds from the buyer or seller are also to be entrusted to the broker. The duty of accounting for all the funds that are given to you for safekeeping, yes, that they don't belong to you, is part of the fiduciary responsibility. Most states require the funds that belong to the client and customers to be kept in a bank account that is separate from the broker's business account to avoid combining or combining of client and customer funds with the broker's business or personal funds. Commonly is illegal even if you don't actually spend the money on yourself and can't account for every penny. Conversion, or the act of using the client or customer funds for the agent's personal or business expenses, also is illegal. Better be careful. Care. Care is a broad and general word that best can be described as agents using their best efforts and skills on behalf of their clients' respective interests. Activities such as helping a seller or client determine a fair asking price for a property and then making every reasonable effort to market the property or expectations of the clients under the care provision of the fiduciary duties. Advising a buyer to hire a home inspector and providing the buyer with information about pricing of other properties are normal parts of the care provision when a buyer is the client. Shh! It's a secret. Confidentiality. The agent is expected to keep all information that can harm the client's interests in the strictest confidence, in addition to any personal information the client wants to be kept confidential, even if the agent's options and information won't harm the client were known. A seller's client desperately needs to sell a property because of a financial situation needs to be kept confidential. A buyer's client equally desperately needs to find a house before the school year starts needs to be kept confidential. And so does the buyer's client's ability to pay more for the property other than he or she is offering. Any client information that can be used to benefit the interests of the customer over the client must be kept confidential. In some places, the duty of a confidentiality is considered to be part of fiduciary responsibility of loyalty. See A Friend to the End, Loyalty, later in this chapter for more information. You better tell. Disclosure. The fiduciary duty of disclosure requires you as an agent to reveal any facts you're aware of that benefit your client. Disclosure applies to information that may benefit the client even if the client hasn't asked about it. As an agent, perhaps you know that the town is undergoing a tax assessment that dramatically maintains the taxes on the houses in the town, and that your buyer and client wants to buy a house for the first time, doesn't have a clue what the reassessment is. You, of course, can at least answer the state exam question about reassessment because you read chapter 16 in this book, right? A buyer's agent is required to tell your client about the proposed assessment, even though they didn't know enough to ask about it. Disclosure also applies to information that can hurt your customer's interest and that your customer has asked you to keep confidential. Perhaps your buyer customer reveals to you that some recent financial difficulties that may be getting a mortgage difficult. Regardless of whether your buyer customer asks you to keep the information secret, you need to tell your seller client about the possibility that the buyer may have difficulty getting a mortgage to buy the house. See Meeting Obligations, the relationship between the agent and the customer, later in this chapter for more on agent responsibility to customers. Disclosure is represented broadly. For example, the agent duty to promptly give all efforts to the seller client is considered part of disclosure. The agent who decides to buy his principal property is something that must be disclosed. An agent buying a house that he has listed for sale is called self-dealing. Other people involved in the transaction, like family members of the listed agent who is interested in buying the property, is information that has to be disclosed. If the information can help your client in any way or might harm him if it doesn't know it, it must be disclosed. Keep in mind that disclosure that in part of an agency fiduciary responsibility isn't the same as a seller's obligation to disclose latent and material defects. In many states, the seller, whether or not she uses a real estate agent service, must tell a buyer any bad news about the property that isn't readily visible by the normal inspection. Rather than a special professionally done home inspection and or would have material impact on the buyer's decision to buy the property. You should also remember that this type of disclosure isn't governed by the fiduciary duty of confidentiality, see in previous section, or obedience later in this chapter. See Discovering Defects later in this chapter for more. One reason why states adapt agency disclosure rules where agents must tell all of their involved exactly who they represent and what that means is the fiduciary requirement of disclosure of the principal. Too often, buyer customers begin to get so comfortable with the real estate agent that they reveal information that can hurt them in a negotiation, in which the agent must reveal to his seller client. The customer either forgets that the agent represents the seller, or never fully understands exactly what that means in terms of fiduciary duties. For more, see Letting Everyone Know, Agency Disclosure Agreements, early in this chapter. A friend to the end, loyalty. Loyalty means always putting your client's interests above everyone else's, including your own. You may want to read the last phrase again, including your own. You must never profit by doing something against your client's interests. You're representing a buyer who wants to offer $200,000 for a house. You know the seller will take $180,000, and you're being paid a percentage. If the total commission paid to the seller and brokers based on the final sales price of the house, that means the higher price for the house, the more money you'll make as an agent, right? I'm going to be blunt. Even though disclosing the seller's acceptable price is against your interests and you'll make less money, you nevertheless have to advise your buyer or client to make the lower offer. If you don't, you're violating the fiduciary duties of loyalty and profiting at the expense of your client. Yes, ma'am. Obedience. Obedience is a fiduciary duty. It requires you as an agent to follow the instructions of your principal. Obedience is sometimes referred to as faithful performance. The only limitation to adhering to the duty of obedience is if the client's instructions are illegal or unethical. If your seller client gives you instructions to violate some provision of the Fair Housing Act regarding marketing the property, the fiduciary duty of obedience doesn't require you to break the law and to obey the client's orders. I covered fair housing laws in Chapter 5. The obedience requirement also doesn't extend to keeping things confidential regarding problems with the property itself. If your seller client instructs you not to tell potential buyers about a leaky roof, you wouldn't obey the client because buyers have the right to have that kind of information. Making obligations. The relationship between an agent and a customer. Clients or principals clearly benefit from the representation by the agent's customer, who sometimes are thought of as a third party to the transaction, have rights too. Remember that the customer can be either the buyer or the seller, depending on who the agent is representing as the principal. The agent is obligated to see that the customer gets whatever the customer is entitled to, although not quite the same thing as the client-agent customer relationship. A seller working alone may also have obligations to the buyer. The agent obligations to the customer is outlined in most places as providing honest and fair dealings. Agents must be honest and fair with the customers, including property accounting for the funds left in their possession. See who has the money accounting early in this chapter. Reasonable care. Agents use their skills and expertise to help customers, provide that doing so doesn't compromise their client's interests. Disclosure of material facts. Check out the section that following for more about the specifics of disclosure of information to the customer. Beyond an agent being trustworthy in handling the customer's funds, the customer mostly is entitled to information. I talk about several kinds of information that the agent is obligated to provide, regardless of whether the customer is the buyer or the seller. The type of information principals and agents are obligated to reveal vary from state to the next, and frequently are interpreted by the courts. I only briefly mention the various things that you may have to reveal, so to be sure to find out, your state suspects an agent and a client to reveal to the customer. Just to be clear, in case you didn't catch this, the seller acting alone without representation may have disclosed obligations to the buyer as governed by your state, even though no real estate agent is involved, except their to be a question or two on the state exam test about this. Remember, the disclosure of these facts applies to the customer, whether it is the buyer or the seller. In most cases, real estate agents deal with seller clients and buyer customers. So most of my examples approaches issues from their perspective. Discovering defects. Latent defects are problems with the property that the buyer, customer, or buyer agent wouldn't find out about through a normal inspection. Some states interpret latent defects to mean structural items and safety items. Structural items are things like problems with the foundation. On the other hand, the things that need to be revealed usually are called material defects. The word material in this case means important. A latent defect, such as a crack in the plaster in the closet, wouldn't necessarily be a material defect because it's not very important. It probably wouldn't affect the decision of an average buyer to buy the house. Disclosure of environmental risks, particularly the ones that come proposed with health risks and hazards, may also be information that you have to disclose. A leaking underground oil tank or the presence of a nearby nuclear power plant has to be disclosed to the buyer customer. The seller may also have an obligation to reveal material or latent defects. In some states, real estate agents' liability has been reduced by the adoption of specific forms that must be used as seller disclosure statements, in which the seller is responsible for telling potential buyers about the condition of the property. Check this out in your state. These forms may more or less be made mandatory and may carry financial obligations with them, as in money paid to the buyer if they're not completed by the seller. The agent often advises the seller of these obligations or tells them to check with their attorney. Get the details on what disclosure forms your state may have. Look at stigmatized properties. Stigmatized properties are properties where events that made the property less desirable to some people have taken place. The events doesn't have to be documented as fact actually happened for the property to become stigmatized, but the agent may still have an obligation to tell the customer about it. A known murder or suicide can stigmatize a property because some people don't want to live in a house where something like that occurred. Reports of the house being haunted by ghosts can also stigmatize a property, even though no hazard evidence proves the haunting. Stigmatized properties is the extreme state-specific items in disclosure because it varies interpretation by different states and different court decisions regarding the requirements for disclosures. Be sure to check out because as your agent you may disclose your obligations and therefore may be tested on this in the exam. Respecting Megan's Law. The interpretation of Megan's Law, a federal enacted law that requires registration of sex offenders with the police and possible notification of neighborhoods regarding the location of sexual offenders, varies by state. Interpretations regarding responsibility of a real estate agent with respect to providing this information to prospective buyers also differs. Some states may require disclosure of the sex offender's whereabouts to possible buyers. Some may require disclosures only in response to the direct question or providing a response to include information about the sexual offender's registry. Check out your local state requirement to be sure. And remember, you may have different obligations depending on whether you've got a buyer or seller client customer. Finding out about fraud and negligent misrepresentation. This is a pretty house on the street. When you, the seller agent, says that to a prospective buyer, they realize you're giving them your opinion. They can also quietly, easily check it out for themselves. What you just done is puff the property. Puffing is exaggerating the virtues of the benefits of a property, and it isn't illegal, and it's done all the time. On the other hand, if you say properties values are going to go up 10% a year for the next few years, you seem to be stating a fact, but the buyer has no way of checking that out because no one can predict future. As an agent, you're perceived to be an expert to the customer, and they have a very reasons to believe you. However, if you're wrong, you could be in trouble. Worse yet, this is an outright false statement that you know is wrong. No, sir, there's no plans to extend the 6-lane road past your house. In court, which there is where it may end up, your action is in either these examples can be interpreted as fraud or an intentional misrepresentation done in order to sell the property. Negligent misrepresentation is a little trickier than puffing and fraud. If you don't know how something, you can't be expected to disclose it. Sounds right, but it isn't. Negligent misrepresentation is when you don't disclose something because you didn't know it, but you should have known it. As a real estate agent, the public expects a certain expertise, knowledge, and level of care to be evident in your work regardless of whether you're dealing with a customer or a client. The location of a new highway that will bring truck traffic down a residential street of a house you're trying to sell has been all over the local papers. Because you don't read the local papers, you neglect to mention this information to your buyer from the town, not out of town. By not telling the customer, however, you may have committed an act of negligent misrepresentation because the buyer expects you to know about such things. Making money. No, not at the copy machine. A discussion about how real estate agents are paid usually follows a discussion about agency relationships because agents get paid if and when they fulfill their agency duties and complete the work of an agreement that they've signed. Helping someone sell or buy a property, like any job, agents get paid when they accomplish what they were hired to do. The problem with the real estate business is how you define the phrase accomplish what they were hired to do. And because several people are involved in the typical real estate transactions, including the buyer and seller, and probably two brokers, who pays what to whom, why, and when isn't as straightforward as when you get your paycheck every week at an office. In this section, I give you information about some of the issues that exam writers write to deal with regarding how agents earn their pay and how it relates to agency laws. For more information about agents' payments, see looking at listing agreements and examining buyer agency agreements earlier in this chapter. I'll also give you some generally applicable information about fee arrangements in this section. But remember, all of it is subject to your specific state laws and regulations and to interpretation that your state courts may be made. Payout. Deciding who needs to get paid, an agent. In a normal business arrangement, the person who hires you pays you. But who said real estate is normal? In this section, I take a look at some possible fee arrangements. In many, if not most, real estate transactions, you're hired by sellers to be their agent. You owe your fiduciary responsibilities and they pay you. So far, so good. But when you're hired by the buyer as a buyer agent, you owe your fiduciary responsibilities to the buyer. Yet in many buyer agency arrangements, you'll still be paid by the seller. Feel free to read the sentence again. It's correct. You owe your loyalty and all your other fiduciary duties to the buyer, but will be paid by the seller because of the simple rule that you need to remember. Generally speaking, fiduciary responsibilities does not follow the source of the fee. This means that you can represent person A and be paid by person B, even if your job is to represent person A against person B. Looking at an example of a seller paying a buyer agent may help you understand. Broker A is hired by seller A as the seller's agent. Broker A will be paid a fee, usually in the form of a percentage commission based on the sale price of the house. To sell the house quickly and at the best price, Broker A puts the word out among other brokers in town that he has a house for sale, which is what usually is called a listing. Broker A may do this informally by phoning a few other brokers in the area or through multiple listing services, which is more formal arrangement for sharing information or for sharing listings. See looking at listing agreements early in the chapter. He offers to split the commission with any broker who brings someone to him who buys the house. Most likely, eventually executes a written agreement for sharing the commission with the other broker. Broker B is acting as a buyer's agent for buyer B, and brings buyer B to seller A's house. Buyer B likes the house and buys it, and broker B will be paid a share of the commission that broker A offered. Remember, broker A gets paid by the seller, and throughout the transaction, broker B represents the buyer. The seller doesn't always pay the buyer agent fee. The buyer can and sometimes does pay his broker fees himself, an arrangement that is particularly true in this case of a buyer signing an exclusive buyer agency agreement in which the buyer must pay a fee no matter how he finds the property. So even if the buyer ends up buying a house directly from the owner with no broker involved, he still has to pay his agent a fee. Finally, there's a buyer agent and a seller agent are involved in a transaction. It's also possible for the buyer and the seller each to pay their own agents. Just remember, your fiduciary responsibility goes to your principal, which is the person who hires you, even if you receive your fees from someone else. Ready to go? Knowing when the agent should be paid. A question in the real world and on state exams is, when during the process do real estate agents earn their fees? The answer is when the broker receives a ready, willing, and able buyer. A ready, willing, and able buyer is someone who agrees with the seller and to all the terms of the deal and is prepared to do whatever it takes to buy the property. For example, if a buyer doesn't have the full price in cash, he gets a mortgage. The broker in this case is considered the procuring cause, a fancy term for a person who brought the deal together. An interesting factor that you notice about the answer is that it talks about the transaction from the seller's agent's point of view, because most agents still represent sellers, although a buyer agent is growing. Buyer agent fees still are paid primarily by the seller, as this previous section mentioned. So don't grow confused or worry about a question that deals with the agent's fees is earned. The ready, willing, and able buyer answer will be fine. Another factor to notice about the definition of when a fee is earned is that it says nothing about actual transferring ownership of the real estate from one person to another. A fee is earned when the minds of a seller and a buyer meet in agreement. A meeting of the minds with simply is another way of saying that the buyer and the seller have agreed to terms and are prepared to complete the transaction. A fee may well be owed to the broker, even if the property ownership doesn't exchange hands. If a seller agent produces a ready, willing, and able buyer who is ready to buy the property at the seller's price and has the money to do so, if for some reason the seller changes his mind and refuses to sell the property, the broker still is entitled to a fee. Generally, whenever the broker is the procuring cause of the transaction, the seller client does something to cause the sale not to happen, the broker is entitled to compensation. Parting is such a sweet sorrow. Ending an agency relationship. A real estate agency relationship can end in a number of different ways, depending on the reason for the termination, the particular circumstances, and what is negotiated. The broker may or may not be entitled to compensation. You also need to remember that the fiduciary duties and confidentiality survives the ending of the agency relationship. A broker may not reveal information received from a client even after the client stops being the broker's client. Here are some of the ways the agency relationship can end. Completion of the terms of the agreement. This method of ending a relationship sometimes gets forgotten. The relationship ends when you do what you agreed to do. Obviously, the agent receives payment in the situation. Expiration of time period of the agency agreement. Agency relationships are written for a limited time period, with 6 months being typical. If the agreement expires and no sale has accomplished, the agency relationship ends with no payment to the broker. Destruction of the property. If the property is destroyed by natural or other disasters, such as a fire, a flood, a tornado, and so on, the property that was for sale no longer exists in its original form, so the agreement ends. No commission is paid, and yes, the owner can re-enlist a now destroyed house and semi-vacated land for sale. Taking of the property through eminent domain proceedings. Condemnation. See Chapter 8 for more about eminent domain. Because the property doesn't belong to the seller anymore through no fault of his own, no commission is owed. Bankruptcy. A bankruptcy filing by either other party, principals, or agents can end an agency relationship. It is unlikely that the commission is owed. Agreement by both parties. Both parties agree to end the agency relationship before the terms of the agreement are met. In other words, no transfer of property takes place. An ending like this might result in some payment to the seller brokers for things like advertising costs. Death or declaration of incompetences. When either party dies or is declared incompetent, the agency relationship is ended and no commission is due. But a broker may seek to collect some costs like advertising from the estate. Renunciation or revocation. Renunciation indicates the desire of one party, but not the other, to end the agency relationship. Permission to end the relationship is the way varies from state to state, so to be sure to check it out. And the technical terms for this method of ending a relationship is reunification, renunciation by an agent, and a revocation by the principal, depending on particulars. Reunification or revocation. Reunification or revocation indicates the desire of one party, not the other, to end the agency relationship. Permission to end a relationship this way varies from state to state, so to be sure to check it out. The technical terms for the method of ending a relationship is called reunification by the agent and revocation by the principal. Depending on the particular circumstances, one of the parties may be able to collect money from the other. The information in this section on ending agency relationships is pretty general, but it covers the basic ways an agency relationship can end. However, you can definitely need to check it out whether any of these methods are permitted in your own state, or if other ways of ending an agency relationship are acceptable. And that was part 2. So you want to sell real estate, the job of basic laws. Chapter 4, understanding agency laws. Thank you very much.